What's up? What's up, everybody? Let's get settled here. Get settled. What's up? Let me know if I have notifications. Let me know in the chat too. I don't know. Let's see. Good afternoon. We're back. You don't know what I did to make it back in time. Woof. Woof. The shit I had to finish in a rush. But it's over now. So we got the Diddy stuff happening and then Bryan Kohberger starting in a bit. So we're going to be watching both. It looks like the judge hasn't come back or decided yet. Let me see here real quick for Diddy. Not yet. So we're still good on time. And then also, let me get this link over here. Okay. Kohberger hasn't started yet either. So we're good. I made it. I made it. Hustling, grinding, sweating. It's been a crazy, June was a crazy month. I got so much done. You wouldn't believe how much I've had to get done. Woof. All right, let me see. You guys in the chat here? Are we live? Are we good? No notifications again? Oh, Kohberger's in the court. Let's see. Let's see. Okay. We'll have Kohberger up while we wait, I guess. While we wait for the judge's decision.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and, Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye. Here as well.
I need to find out about my card too. Yeah, they haven't gotten back to me.
Miss Allen is here as well.
Miss Allen is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern.
Still no notifications.
Otherwise, first, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case.
Wow.
This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never, take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me. Period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this because, again, it is not appropriate and, frankly, not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, and what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families
Who's going to accept
of
it,
the
basically?
defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process.
Voir dire.
And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly, and so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum the defendant will plead guilty to all 5 counts in the indictment, burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence. All 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count, so theoretically the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right.
By the way, guys, I'm watching for the Diddy stuff. No updates yet. All right, I'm waiting. I haven't said anything
Have
yet.
you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counteroffers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right.
Oh, he stood up. Look at him.
While you're standing, actually, why don't you
proud.
take the oath from the clerk?
I got a bigger screen for you guys.
Yes.
All right, and Mr. Kohberger, just to make it easier, you don't need to stand when you speak to me. I appreciate
That boy jumped up.
sign of respect, but for convenience, you can remain seated, all right?
His family's there.
Before I start asking you questions today, have you consumed, substantive questions, let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include on count one, the burglary, a fine of up to $50,000, and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with, that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
Damn, okay. That's going to break a lot of hearts. I know a lot of
Counsel,
ladies out
obviously,
there
there've been
upset
a number of
and sad about
motions
that.
filed to suppress evidence in this
Oh,
case.
man.
Other
He
than
was
those
forced to say
filed,
that.
are
He
there
was
any
forced to
other,
say that.
motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Are
Given
you
your
sure?
choices, do you believe it's in your best
Are you
interest
double
to plead
sure?
guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case should you not plead guilty. Did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right.
Yes. Yes. Yes.
So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
Some people are big time in denial that this is part of the plan, and that he's doing this because he didn't want to die, but that they're going to come back after. But
For the record,
there's no coming back. To me, it seems he's admitting to everything. He's had to admit to it.
with the guilty plea advisory form, a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogen, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, and with premeditation?
This is going to upset a lot of people, I'm telling you.
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And
Wow.
did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor.
Oh, they're going to do that too.
Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Latah County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was the traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow, that would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked.
This is taking me back.
Defendant
Memory
entered
lane.
the residence, went to the third floor, and with a knife, killed Madison Mogan and Kaylee Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But
Single drop of
it's
blood.
important to note, single source male DNA was on the snap of that sheath.
Single drop.
The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims.
They were pushing that for a long time too, the sexual stuff.
There were two other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw
bushy
the
eyebrows.
defendant was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen.
By the way, guys, Inner City Press says there's nothing to report right now as far as Diddy. The bail letters were due at 1 p.m. They were docketed at 1:30. Combs' lawyer. So I'm gonna read you. I'm gonna let this play. This him giving like the details of what happened, the prosecution side of what happened, and then I'm gonna read the letter that the defense submitted to the judge. I'm gonna read that. But right now, the judge still hasn't decided, so we're waiting. In the meantime, we're just listening to Kohberger. So we'll listen to this. I'll pause in a little bit. I'll read the letter.
In his Elantra, drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning.
He did come back, yeah.
He was there for about 10 minutes and then returned to his Pullman residence.
Damn. Probably to watch,
about
to see.
9:30.
The cops are there.
State's evidence will show, evidence taken from the defendant's phone,
Sick
that
guy.
he took a selfie of himself on his phone.
Yeah.
in what appears to be the bathroom of his Pullman apartment with a thumbs up.
This dude, yo, wow. And this is the
Defendant's phone
intellectual. He's
then
an
went to the
intellectual.
Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This
Educated.
area is the confluence of the
Dumbass.
Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th of 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, in public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. Defendant's car
He thought he was Dexter.
Meticulously cleaned
That motherfucker
inside.
thought he was Dexter.
And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing
Look at that.
when he was working on his pre-doctorate degrees.
Okay, all right. Let me do some Diddy updates, and we'll get back to this in a bit. Okay. Because the defense submitted their letter, the prosecution submitted their letter, and I want to read them to you. The judge hasn't decided yet, but I feel like we need to read this so I can give you guys a little bit of context with the whole Diddy stuff. So let's just do this real quick. I don't think we need to read the whole thing from the defense. The prosecution was pretty short. But it says, "Dear Judge, okay, Mr. Combs moves for release on appropriate conditions pursuant pending a sentencing proceeding. Given the jury's clear verdict acquitting Mr. Combs of RICO conspiracy and sex trafficking counts, continued detention of Mr. Combs is inappropriate. As these proceedings have demonstrated, and as we told the court from the outset of this case, Mr. Combs came to New York to surrender in order to defend against the government's charges because he was committed to showing his innocence. Since his arrest and detention on September 17, Mr. Combs has obeyed the court, respected these proceedings, and demonstrated model behavior at MDC. And today, the jury unambiguously rejected the government's allegations of Mr. Combs ran a years-long criminal enterprise or engaged in sex trafficking, the core of the government's case. Mr. Combs stands convicted of 2 Mann Act accounts, and his sentencing exposure is substantially lower than when the government initially sought detention. The court should release Mr. Combs on the proposed conditions." And so, aside from the burden of proof resting on the defendant rather than the government, the operative standards are the same as those outlined that the court should consider the outset proceedings. As for flight risk, it is insufficient to rely on only evidence of commission of a serious crimes and the fact of potentially long sentence to support a finding of flight risk. Rather, the court must sensitively consider several factors, including the length of prison time the defendant faces and his individual circumstances, whether familial and community ties make flight unlikely, his actual ability to flee and evade law enforcement, evidenced by such things as whether he has a passport, familiarity with other countries and locations, and financial ability to do so. Okay. Regarding dangerousness, there are 2 components. First, the question is whether the defendant poses a risk to safety of the community. The question is whether the defendant is likely to criminally recidivate, commit future crimes against the community as a whole. Mr. Combs presents no risk of flight or danger. During the initial bail proceedings, the government argued Mr. Combs was a flight risk because he was charged with serious offenses carrying significant and in some cases mandatory terms of imprisonment. The circumstances are now opposite. The base offense level for a violation of a Mann Act is 14 because there are 2 counts of conviction relating to 2 separate victims. Section 3D1 instructs the counts are grouped separately because the offense level for each is 14. An additional 2 levels are added, resulting in a total offense level of 16. Mr. Combs is in criminal history category 1. This results in an expected guidelines range from 21 to 27 months. Mr. Combs has already been incarcerated for 10 months. His sentencing exposure which we fully respect and do not seek to minimize in any way, is in fact low, and so any corresponding risk of flight. Mr. Combs, prior to his arrest in 2024, further demonstrate that he is neither a flight risk nor a danger to the community. Mr. Combs knew he was under investigation and likely to be charged earlier in the year, but he was not arrested until September. Okay, when it became apparent to the council that Mr. Combs would formally be charged, Mr. Combs did something extraordinary. He left his home in Miami, traveled to New York, the very location of the prosecutors and agents investigating him. Through counsel, Mr. Combs promptly told the government that he had voluntarily come to New York, offered to tell them specifically where he was, and he offered to turn himself in at the appropriate time. The government rejected that offer and elected to arrest him, but Mr. Combs' own conduct was the opposite of the flight. He affirmatively and proactively sought to cooperate with the legal process. Even before his offer to self-surrender, Mr. Combs demonstrated a pattern of trustworthiness and cooperation. Mr. Combs' residence was searched in March 2024, and even before that, Mr. Combs and his counsel were aware that the United States Attorney was investigating him for serious crimes. Throughout this time, Mr. Combs acted forthrightly and remained committed to the process. First, shortly after the searches on April 1st, 2024, counsel took possession of Mr. Combs's U.S. passport. On the same day, his counsel advised the prosecutors that Mr. Combs had surrendered his passport, that defense would not return it to him, and that he would not leave the country. The passport remains in defense's counsel possession. Second, counsel advised the government that if Mr. Combs intended to travel domestically, counsel would inform the prosecution. All subsequent travel was done with the government's knowledge. Third, Mr. Combs voluntarily relocated to New York. On September 5th, 2024, once Mr. Combs arrived in New York, defense counsel immediately informed the government of Mr. Combs' whereabouts. Fourth, he paid off the mortgage at his residence at 2 West Star Island in Miami. This payment was $18 million, was one reason alone, so he would have this $48 million residence-free and clear of any encumbrances, so that it can be used to secure a bond. So they're saying it's not a flight risk. Other factors to consider. Basically, free Diddy. That's what they're saying. That's what they're saying. Mr. Combs had, just a few examples, what Mr. Combs has missed. Since he's been incarcerated, he has missed his biggest moments of his daughter's life. He has missed his twins' high school graduation. They did not have any parent there with them because his mother, Kim Porter, had tragically passed away in 2018. He missed his twins' prom. He has a minor daughter, 2.5 years old, who has been without him for 9 months. He needs and wants to be with and remain with his family. At today's hearing, the government suggested that Mr. Combs could still be a danger in the sense that he still had the means and the ability to commit prostitution crimes. With all due respect, that suggestion is unsupported. The government had, for an extended period of time, a pen register on his phone. Mr. Combs never called any potential escorts or prostitutes, nor did he make any effort to arrange meetings with escorts or prostitutes, nor was he with Jane in New York. In any event, reasonable conditions would ensure that Mr. Combs would have not have the ability to arrange meetings with escorts. Okay. So they list cases here. Cases overwhelmingly support release under the circumstances. In cases that, as it stands, is simply not the same category of other cases where detention for Mann Act defendant was deemed appropriate. So they're listing cases to cite their argument. The proposed release conditions: $1 million bond, co-signed by Sean Combs, his mother, his sister, the mother of his oldest daughter. Combs will be restricted to the Southern District of Florida, Central District of California, and Southern District of New York. Mr. Combs' passport surrendered to pretrial services, drug testing as ordered by pretrial services, all other standard conditions of pretrial supervision. So that's the defense's claim. That's the defense's letter. Let me just take a look. We're going to take a look at the prosecution, but let me just make sure. I don't know if the judge decided yet. I haven't looked at the chat. Let me see. Take a look at the chat in case you guys are screaming at me. He decided. He decided. Okay, hold on. Update 2. Hearing that after the submission just now, bail letters by the Combs attorney of office, judge will reconvene. Okay, with the parties at 5 p.m. So he's coming at 5 p.m. back. The judge will make a decision at 5 in 3 hours. So we have time. We got Kohberger. We got documents. We're chilling. We're writing. Please hit the like button for me because we got 194 likes and almost 900 people on YouTube. And I have no notifications. When the hell am I going to have notifications again? I have none all day. Bro, no notifications. So please hit the like button because it helps me out with the algorithm. Please sign up to the mailing list, please. I would appreciate that. And yeah. So let me just read this other document, and then we'll continue back with Kohberger and catch up. The prosecution. This is a short one. It's just one page. So the prosecution says, who's outside for comments? Who outside for comments? I got the feed on the right-hand side. Diddy. Now all of a sudden, Newsom to announce $750 million film and tax TV credit. He's trying to match up Trump. Hey. I don't see anything outside with Diddy right now. I got 1 feet on the side. I'll take a look at oh, that's Kohberger. Oh, they took a little break with the Kohberger. So we're perfect, guys. We're perfect. I don't see anything happening outside though. If you want to email me, Lynn. So let me get this page done so we can continue. So, dear Judge, I'm writing to express my grave concern over the prospect of Sean Combs being released from custody. While I appreciate the fairness you have shown throughout the proceeding, I feel compelled to be unequivocal about the danger he poses to the public and to the individuals who have risked everything by coming forward. Mr. Combs has a long, well-documented history of violent, coercive, and retaliatory behavior. Coercive, and retaliatory behavior. Over the years, he has repeatedly escaped meaningful accountability, and each time he... Oh, who's this outside? Hold on. That's the family. No, excuse me.
Family leaving court again. Family leaving court.
All right. So I'll keep an eye. So they believe he's a danger to the public, and they say that, and each time this has only reinforced his sense of impunity. If he is released, I have no doubt he will see it as yet another license to continue intimidating, threatening, and harming people who challenge or expose him. Many of us have firsthand knowledge of the fear he instills in those around him. I can say without hesitation that he is a serious and immediate threat to the victims, witnesses, and the broader community. His pattern of violence, particularly while engaged in the trafficking of individuals for prostitution, combined with unchecked substance abuse, make it clear that he is not ready to re-enter society safely or responsibly. To release Mr. Combs without substantial consequence would undermine the integrity of the process and send a dangerous message that wealth and influence can shield someone indefinitely from accountability. It will also endanger those who cooperated with this investigation under subpoena, who are already in fear of retaliation. I urge you in the strongest possible terms to prioritize the safety of the victims and witnesses over any consideration of leniency. Mr. Combs has had countless opportunities to change, and he has chosen instead to escalate his harmful conduct. Allowing him back into the community now would be a profound mistake. Thank you for your time and your commitment to protecting the public from those who repeatedly demonstrate that they are unwilling to respect the law. All right.
And he had that knowledge and skill.
Oh shit, they made it unavailable. What happened? I'm gonna have to rewind it. Let me get long crying. What? They took a break for the day too. Everybody taking a break. Woo-doo-woo!
Found on the knife sheath next to Maddie's body at the crime scene. I can tell the court and the public the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Manny Mogan, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you, Your Honor.
Thank you. All right, based on the state's proffer and importantly based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count one, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count two, murder in the first degree as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count three, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count four, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count five, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. So because of the plan to bring in so many jurors to fill out questionnaires, I had
Okay, so that was it for that. And then they had microphones out there. Let me fix this crazy ass screen. I just adjusted it because I wanted to give you guys a full screen of Kohberger. Kohberger. But I got some stuff that we got to talk about. Let's see. First of all, did they ever do anything here? No, that's for later. Okay. So let's do this because I want to clip something. I want to clip something for the channel. Why isn't the button working? Maybe it's not working. Oh, there it goes. It's working. All right. I want to show you guys something. This is crazy. Hold up. Let me set up the screen real quick. Hold up. Oh, Allah. Come on, why don't you listen to me? Did he do it? Did he not? Did he do it? Did he not? Did he walking free? So the judge is coming back at 5 p.m., right? Hold on. Hold up. Test me. Shout out. Oh, here we go. All right, I got some clips. I'm going to clip it for the clip channel. You know what I'm saying? Did he do it? Okay, what did I want to do? I want to do something. Oh, yeah. There you go. All right. So they're saying Diddy supporters are celebrating outside of the courtroom. First of all, when Diddy heard the verdict, they said that he dropped to his knees and bent over. I mean, just this is a W for him. And now they're saying that these people outside of the courtroom, supposedly alleged Diddy supporters, were spraying baby oil. Oh my God. On top of each other. Is that Armand? That's Armand Wiggins? This lady's a troll, the lady in blue hair. Oh my God. These people were popping bottles. Oh, wig came off. Oh.
I don't know what she gonna do, y'all.
Oh my gosh. That looked like Armand Wiggins. They're celebrating. Yeah! Wow. Oh my gosh, this even made it to the news apparently, CNN?
Proper and etiquette that is happening inside of a courtroom. No, instead, I kid you not, people are pouring baby oil on one another outside this courthouse. Baby oil having a very big play in the freak-offs we heard about. You have people saying it's not Rico, it's Frico. You've got
Frico? Oh my
coming
God.
when the mother of Sean Diddy Combs, Miss Janice, got out of the vehicle just a few moments ago, really, behind us and walked inside to elated cheers and her greeting the crowd. Every time the family, the children, the 6 adult children come in, 3 boys and 3 girls, they are met by cheers, and also at times throughout the course of trial, met by scathing and disrespectful comments as well. A lot of profanity.
Wow. So they're celebrating, popping bottles, and Fearbuck posted that academics were celebrating that Diddy beat the case. Let's take a look.
In a matter of count 1, not guilty. Racketeering, he beat. Sex trafficking of Cassie, he beat. Transportation, I told you, he got that one, but he be fine. He be out in a couple months. He be straight. Oh, we back on road, chat. We back on road, chat. We back on road. Yo, Cassie, get the fuck on out of here, Cassie. Get the fuck on out of here. Yeah, my boy was doing some prostitution shit. He should have been just doing the escorting, but he wasn't sex trafficking them hoes. Come on, man. If he definitely not guilty for Cassie, he ain't guilty for Jane Doe. She's a hoe. She a hoe.
Oh!
She's a fucking hoe.
Right,
That's a
on.
fact. Here we go. Here we go. Listen, you know what this means? All you other bitches that had whatever type of thoughts like, oh yeah, that's sex trafficking? No, it ain't, hoe. You hoes gonna have to live on your knees for life. I'm sorry. Okay.
Yeah, be careful me flying out the business, man, because they'll catch you with something.
This is at least some redemption for Diddy. Sex trafficking for Jane Doe? No, not guilty.
Wow.
Transportation? Guilty. 2 out of 5, chat. That boy beat the case. He beat the case. He beat the case. He might even come home today. Time served, man. Time served. All you Cassie Jane Doe hoes, it's a wrap for y'all. That shit is over. And they should, I wish this judge could have dismissed all them civil suits too. All y'all niggas, go back to being broke. It's okay. Give this nigga back his baby oil and let him go have his Astro Glide. Let that man go back to the pre-freak office crazy chat. I might have to put in an RSVP. I ain't even going to y'all chat. I might have to RSVP chat. I might have to be the next one chat.
RSVP? RSVP what? What the hell is he talking about? RSVP what? Wow. Diddy, man. Big W for Diddy. He's been already locked up for 10 months. Diddy, there's just people outside celebrating, oiling up each other. Wow. Thank you, Layla, for the info. Wow, 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 wow. People celebrating. Cookouts, bottles. Wow. Oh, we got another video of the party. Hold on. Okay, hold on. There's another video of them partying outside. They're having a Diddy party. A Diddy party. Wow.
Armand!
That's Armand, yeah, I knew.
Look! Armand!
Oh, that's Lovely T? Lovely T streaming out there.
Armand is a fucking mess!
And they celebrating P. Diddy free. Wow. Woo. What a mess, child. What a mess, child. What a mess. All right, man. So we're going to be back. We're coming back at 5 o'clock. I'll be back at 5. Hopefully we have notifications then. I don't know what's going on. No notifications today. Like I said, please sign up to the mailing list, man. I fixed the list. Sign up to the mailing list because you guys, when the notifications don't go out, I don't see you, the YouTube notification. So sign up to the mailing list. Okay, go to iCkEdMeL.com. Sign up to the mailing list. I want to take a little break, get some lunch with the baby. I rushed my ass. I was sweating all kinds of stuff. I'm done with the apartment. I'm gonna take a little shower too. But do a little lunch, shower. We'll be back at 5 to find out if Diddy walks out today. Will Diddy walk? What do you guys think? Let's do a quick poll. Do you guys think Diddy will walk today? Will Diddy walk today? And then we'll come back later. Who's that? Is that Mandy? Mandy, thank you for the 31 months. Appreciate that. The 2 years. People are sick. I know. Going on 3 now. 3 years. Kohberger was quick. Yeah, they're coming back. Thank you, Mandy. They're coming back on July 23rd, at the end of the month. I guess for the victims. Kohberger, I was surprised it was a short hearing. The Gonsalves family disagrees with this plea thing, and I forgot Cornudo's family, I think, disagrees, but Chapin's family agrees with it. You know. What do you think? I don't know. I don't think he's gonna do a lot of time. He's already been locked up for 10 months. He got the 2 lesser charges. If he has to serve time, I don't think it's gonna be long. If I were just going to guess, we only have 95 votes. Come on, put in your votes. I'm going to take a screenshot. If I had to guess, I would say my guess is he's walking. Just, I know, 50-50. Every time I get a 50-50 poll. Well, now it's a little bit leaning a little bit. 56-44%. My guess is he walks. But the only thing is, I'm thinking the judge might be afraid of the repercussions. Oh my God, you let him free! Oh. You know, maybe 5. Maybe he only gets his 5. You think he's gonna get 5 years? That's still a long time. When you're this age, or well, he's older, but he's older than me. But when you get older, man, 5 years. Oof. 20 years, you think, Lynn? 5 p.m. Eastern. They're coming back. Bottom line. I thought we were going to find out now, but the judge gave them to 1 p.m. to hand in the letters. I just read the letters. The judge said at 5 o'clock he'll make a decision. So we'll come back at 5. Hopefully we have a notification so everybody can know that I'm live. People are betting on, will Diddy get jail time? Polymarket did prison time. 58% say less than 5 years. 24% say no prison time. 5 to 10 years is 18%. I don't know, man. Definitely, I say definitely less than 5 years. I don't think more than 5 to 10 years. No, less than 5. Money walks. Bullshit talks. Or did I say that right? I don't know. But all right, guys, I will see you later, man. I'll see you guys later at 5 p.m. Eastern, all right? Love you guys. Hit the like, subscribe. See you later. Bloop.